Oh, it's windy and dusty in Botswana. Oops. Wind and dust. Nah, I don't like that. Good afternoon, Oluwa from Laya. Good to see you too again. You're already missing me. Oh, are you in Lagos? Olufumi, are you in Lagos? Yes, don't worry. So you'll see me at the physical meets. I will be there. Good afternoon, Melody. Tell all your colleagues that the session has started. They should join in. Sure, we'll connect. Sure, I will be there. I didn't want to come, but Stephanie has mandated that I must be there. You didn't see anyone for the physical in Botswana? I'm sure there are more than. Please get in touch with Stephanie or Ione. Both of them will be able to connect you with the other participants from Botswana. Physical for Zambia as well. Ladies, get in touch with Ione. Ione will sort you out, right? She'll connect you. You're welcome, Ashley. How are you today? Good afternoon, Mayowa. You tried, but no one responded. Maybe they didn't see the message. So send the message again. I'm sure everyone is excited for the physical meet, wherever. I wish I could fly into all the countries just to see ladies, but if wishes. Parent has been great. Thank you, Ashley. One day, one of these days, maybe in some cohorts to come, we'll have enough money to bring all the participants into one physical location. But till then, we'll have to make do with what we have. I should fly to Botswana. Well, I promise you that whenever I have to come to Botswana, I will pay you a visit. Do we make that a deal? Okay, we have a facilitator in with us. Oh my, I just realized my video wasn't showing. I just realized my video has not been showing. Ladies, I didn't tell me. Good afternoon, Damilola. How are you?
Hi, Shay. I'm very fine, thanks. Thanks for having me.
Okay.
Loud and clear.
Yes. Can we increase the volume of your mic, if possible?
I'm just going to move closer to the lap. Okay. And try to see. One second, I'm going to try and do that.
Someone says she was looking forward to another assignment. Oh my, are you not tired of all the assignments? Don't worry, send me an email. I'll give you more assignments to do.
Okay, Shay, I'm hoping this is better. Is this better?
Let me see. Oh, okay. It's fine. I think it was from my end.
Oh, great.
It was from my end. It's better. How are you today?
I'm very well.
Okay, ladies. So we have a facilitator in-house, and I think we should... Oh, okay. Hold on a second, please.
I think if Etaya says she can hear you, you're muted now, Shay.
Hi, Dami. It's much better. Much better. Apologies, I had to sort the YouTube audience out. Okay. So ladies, here we are. It's the final masterclass for the Aspiring Entrepreneurs Program, Cohort 2. How do you feel about that? Somebody said she's missing me already. Aha. All good things must come to an end. It's been 6 months of learning. It's been 6 months of, it's been a transformative period really for most participants. For me, I'm very glad, I'm delighted with the news, testimonies of what I've heard, those who won grants, those who got opportunities. I'm really excited because at the end of it, that's really the reason why we have put in so much to have this session. So yes, but the learning doesn't end. We will give you more information about that during the closing ceremony. But for now, to all those joining us from YouTube, good afternoon. How you doing? All right, so without much ado, our facilitator for today is Mr. Damilola Salawu. Just give me a minute, please. Let me introduce him formally. Right, so Damilola heads the technology, innovation, and fintech practice for Olaniwa and Co. It's a law firm. And in this capacity, he provides advice and support to technology businesses across different industry sectors and on different legal issues. He's advised top market players. He's advised top market players in the tech sector on strategic investments and cutting-edge transactions in the Nigerian market, Africa and beyond. He understands the various legal, regulatory, and business landscapes in the technology space and advises on business establishment and market entry, regulatory compliance, corporate structure, and investment strategic partnerships. Damilola is also a partner in the oil and gas practice of the firm, and he has rich experience advising on joint ventures, financing, development, infrastructure projects. He advises on a wide range of finance matters across several sectors, including corporate and project finance and security arrangements. Damilola is particularly familiar with investment transactions and has advised technology businesses, large corporates and SMEs on several investment transactions, whether seed financing or corporate investment deals. He's advised a good number of the biggest names in fintech and technology in Nigeria and on the African continent and globally, including Facebook, Google, Flutterwave, Uber, and Amazon. He's a member of the Financial Services Lawyers Association in UK, and he has consistently been ranked as a leading lawyer in Chambers and Global and the Who's Legal for his technology and fintech and M&A work. Ladies and gentlemen, it gives me great pleasure to invite Mr. Damilola Salawu to take the session on giving us a legal toolkit for managing our small and medium scale enterprises. Thank you so much, Damilola, for honoring this invite. And you can please share your slide.
Okay. One moment, just let me do that. I think it says you've disabled screen sharing.
Okay, hold on a second. I'll just make you a co-host.
Okay,
please
so well,
okay.
Okay, great. One moment, please.
Okay, that's fine.
Okay. I'm hoping everyone can see my screen.
Yes, we can.
Okay, so thanks very much, Shay, for inviting me to spend the next hour or so with you, network. I'm very happy to be here, and I'm happy to have the opportunity to share my thoughts and experiences with you all. I'm always interested in sharing the knowledge that I have, you know, to the extent that it may be helpful to and make a real difference and impact, you know, on the great work that you all are doing. So I'm really happy to be here. I know Sheyi has been kind enough to say a few things about me, but just to say that the work that I've done in the last few years, I've done a lot of work working with, small businesses and large businesses, and it sometimes in the course of our work, we see what I was sharing about this afternoon, are some of the thoughts that I've collected over the years, around how we've seen businesses, particularly young businesses, small businesses that are looking to scale and grow, how the issues that they've sort of struggled with, and what are the key pointers that I think I'm able to share with you, just based on all those that collective experience, over the years, and that I think may be helpful to you. But from Sheyi, I understand everyone here is either an entrepreneur or an aspiring entrepreneur.
Yes.
You have a small business that you're looking to. You have a small business that you're looking to start or to scale. And the essence of this session is just to help you be aware. Because what I found over the years is that business owners, founders are so focused on building a business, customer acquisition, getting this business sustainable, dealing with the firefighting that, comes with doing business in this sort of environment. And sometimes we take our eyes off, the legal aspects of some issues, that could potentially create problems down the line. But we don't think about every day on day-to-day basis. So this afternoon, over the next few slides, I'm going to be just speaking through some of those points. So without further ado, I'm just going to go right into it. Shay, I know you told me I have 1 hour, so just try and keep my head on time. So I know this is not a statistic that I like to talk about a lot, but it's something that I need to put on the table. We know that 80% of small businesses fail, within the first 5 years. We've seen those statistics. And we know that happens because of a myriad of factors, funding challenges to infrastructure challenges, poor corporate governance, legal risks that could tank a business. And these are just a few of those. Of course, tied to poor corporate governance is also, experience or inexperience of the team that manages the business. And the idea behind what I know the Powering team is doing, and the idea in this session is to try and see how we can, collectively put all hands on deck to get this number down to its barest minimum, and have that happen fairly over a longer period of time, rather than just in the first 5 years. So during this class, we'll be talking about legal issues and the perspective I have that could impact on the success of a business. Now, I know sometimes we might have heard some business owners or founders refer to their businesses as a startup. Some have actually taken steps to actually commercialize their business. They're already doing something. They're buying, they're selling, they're creating, they're commercializing, they're reaching out to clients, they're advertising, they're doing all sorts of things. But whether your idea, the idea for your business, it's still in your head, and you're about to take the first few steps in that direction, or whether you've actually started doing business, and engaging with customers, engaging with clients, this masterclass, I think it would be helpful, to either remind you of things you already know, or perhaps point you in the right direction on things you might have overlooked. And so at the end of this session, ideally, you should be more informed about the right kind of business, the structure for your business. When we're talking about business establishment, we're talking about, what kind of business, what structure should your business take? You should be informed about the basics of corporate governance, and what best practice is. You should also be aware of how to manage your legal risks, even for you as a business owner. You should be able to think about, always have your mind's eye on those points that are legal, and then know when to do what to do yourself, or what to escalate, to a lawyer externally. Managing investments. Of course, as businesses grow and scale, everyone's objective for their business is to grow the business to the point where it's attractive to investors. And investors could be commercial investors, private equity investors. It could also be, taking funding from a government agency through a fund, a grant, or a subsidy program, or a stimulus program generally. Of course, grasping regulatory landscapes. I'm sure in the news, we hear the news every day about what the government is doing or not doing. I do a lot of work in tech, for example, And I'm sure for those who are familiar, and there's work going on in Nigeria, we've heard recently that the CBN is taking some steps, the SEC is taking some steps. So understanding what the regulatory landscape is, particularly if you are doing business, doing business in a regulated space, or your business is itself regulated activity, it always helps to understand what the regulatory landscape is looking like. And then, of course, disputes. How do you avoid disputes? How do you manage them? Obviously, we all know conflict is a part of life. Dispute is a part of business. So you can't, or chances are that you will not have a dispute-free journey as you build your business. And so you need to also think about how we avoid them as much as possible. And when they do occur, how we manage them so that the impact on our business is minimal. Okay, so let's start with business establishment. So I said before you start that business, the first step you need to think about, is to think about how do you want to establish the business? What kind of structure do you want to put on your business? And there are different ways businesses are set up today in Nigeria, or even in any sort of in any economy. You could have a business that is a sole proprietorship. That's just you with your business, with your idea. Oftentimes you hear people say, "This business is my baby." You hear, "This business is my baby. This might be my second baby if you have a baby already." And sometimes, and for the majority of those sort of people, those businesses usually start with an idea. Sometimes I know we start businesses out of hobbies, out of pastime. Sometimes we start businesses out of necessity. Sometimes we find ourselves in those situations. But most times, the predominant number of small businesses, particularly in Africa, most of those businesses start, from hobbies and personal interest and skills. And so once as that business takes off, what you really have in legal terms, in structural terms, is a sole proprietorship, and the law recognizes a sole proprietorship as a business name. And so what that means is, so Sheyi Kehinde Peters could have a business that she's running, on her own. Perhaps she's making children's clothes or children's shoes or something. That business, to the extent that there's no distinction between Sheyi and that business, what she's running is effectively a sole proprietorship, and except where where she's not using her name, right? So if she's using a name that's other than her full actual legal name, then she needs to register that as a business name. And once you do that, effectively, your business has legal recognition. But from in the eyes of the law, you and your business are still one and the same. There's no separate legal personality in relation to your business. And so, from a tax point of view, from a self-assessment point of view, from a revenue and a share and a profitability point of view, the money you make from the business is the money that the business has made. And then you pay tax based on your self-assessment business. Now, you may not have a business on your own. You may want to come together with a friend or a partner or a former colleague to set up a business. And I know many businesses that have started this way. Two people who have shared interests, or perhaps maybe one is stronger in one thing or the other. You come together and form a partnership to start a business. And what's a partnership? Legally, from a legal perspective, a partnership is two people coming together to make money, coming together to prosecute an effort to make money. That's a partnership. And so you rather than do this or go it on your own, sometimes it's good to find someone who has skills or strengths that you don't have, and you want to form that synergy so that you can synchronize, you can leverage off each other's strengths and abilities, and you pursue the business. So a partnership is a business arrangement where two or more people come together. Together, they are responsible for the debt of the business and the obligations of the business. They are the partners behind the business. So Sheyi and I can come together and pursue a business, and we'll be partners. We could choose to form a partnership to prosecute that business. And as an alternative to a partnership, and of course, just to say that different countries have different laws that regulate partnerships, and the different kinds of partnerships, but I won't go into too much detail. You have a limited partnership, you could have a limited liability partnership, which is very similar to a company, which I'm going to speak about next. Now, companies are the most commonly used vehicles for businesses. And a company, as we know, could be a private company, could be a public company, but if you start small, most likely you have a private company. And a company, the difference between a company and a partnership and a sole proprietorship or a business name is that a company has separate legal personality. What that means is, if Sheyi and I started a business, so if Sheyi started a company, that company, beyond Sheyi herself as the perhaps the principal shareholder of the business or the only shareholder of the business itself can exist separately of Sheyi. That business can hold property, it can enter into contracts, and it can be bound by the contract. It can sue and be sued separate from Sheyi herself. And so company law generally, recognizes that a company has separate personality from the owner. And that's the key difference between, a company and a sole proprietorship or a sole partnership. So I guess the critical thing here to understand is when you want to start your business, what kind of structure do you want to put around your business? Is this my show only business where it's just you do a business name and you run? Is this something that you want to go with someone? If yes, do you guys want to be in a partnership or do you want to be in a company? Because the two of you can choose to be in a company as co-shareholders in the business. You could own it 50-50 or 60-40 or however you may choose. But the important thing is your plans for your business will determine the structure you put around your business. So if you know that this business, you want this business to be the next Google, for example, or you want this business to be the next Dangote, or you want this business to be the next Chess Center, whatever it is your plans are, that will determine how you structure your business, right? And if you think this business is just a side hustle, you want to just do it on the side, beside your 9 to 5, then perhaps you may want to think about a sole proprietorship. But if it's something that you want to want to go big with, want to bring other investors once you scale, you may have to think a bit more about a company. So I think that's the first step you need to think about: business establishment. What kind of structure do you want to put on my business? Now, just to say, and one last point before I move on from this slide, I should say that because you start out with a sole proprietorship or a business name, doesn't mean you can't evolve into any of the other forms of business structures. It doesn't mean you can set up a sole proprietorship, register a business name, and then eventually when you think this business is growing, it's doing well, it's getting bigger than just me, you can bring other parties in and roll the business over into one or two of the other structures. So you're not stuck because you've chosen one. The important thing is at the point at which you're starting your business, you choose the right structure, and then you continue to evolve that structure as the business continues to grow and perhaps faces challenges or opportunities as you go. And so the last point I talked about, you can have a public company, which is a small company limited by shares, which is usually at least 2 people and at most 50 people. And the public company are larger companies, have larger shareholders, wider shareholder base. Sometimes they may be listed, or they may not be listed on the stock exchange. And we also have companies limited by guarantee, limited companies. Companies limited by guarantee are usually companies that are used for charitable purposes, sort of NGOs and entities like that. So yes, they're not generally profit making, and any income they generate is usually put back into the business, for greater impact and scale. It's not usually for profits. It's not a business that is usually carried out for profit. That's why sometimes you might hear, I run an NGO or a non-profit organization. So moving on to what are the key advantages of a private company? I've already touched on one, which is separate legal personality from the owner. So separate from Sheyi as a founder, for example. Sheyi Limited is a different person in the eye of the law. And as I've said, it has everything that Sheyi can do as a human being, under the law in terms of contracting, holding property, holding property, creating legal relations, suits, the entity can do that, the company can do that. One of the key benefits for a company as well is as the business grows, as the business scales, you can start to bring on board, third parties that have strategic benefits for the business. Of course, if you start a business and you form a company, Nigerian law, using Nigerian law as an example, today, Sheyi alone can form a company called Sheyi Limited. And if she does that, she pushes the company as far as her strength can carry her, but there's a limit to how far she can go and carry the business. She may need someone with experience in supply chain management. She may need someone with experience in logistics. Sheyi's expertise or area of strength may just be in the product development itself. But she may need people, as the business grows, she needs other kinds of support and experiences. And those partners may want a share of the business. And that's why a company is an easy way to bring additional people on board, ensure that they are vested, they have an ownership stake in the business, and the business can continue to grow. Of course, the next key advantage of the business is limited liability. And what that means is that your liability as the owner of the business is limited to your stake in the business. So what that means is if, for example, and I need to say this very carefully, limited liability is just, it's a legal construct that says because the company is separate from the owners of the business, the company can contract and the owners of the business are not liable for that. Their liability is limited to the volume of shares that they hold in the business, and to the extent that that amount of money is unpaid, the value of those shares are unpaid, it's limited to that extent. So, for example, a company can contract, right? And even though she is the owner of the business, of the company, or she's a director of the company, the company can contract, and it's only the company that is bound by that contract. She herself, as an individual, as a legal person, is not bound by the contract, except, of course, she signs as an individual in addition to the company, right? So that's the key thing about limited liability. The company, and as I said here, founders can control their exposure to financial risk and other legal exposure. And that's very different from if you have a sole proprietorship or a business name. As I said, the business and the individual are fused. You are one entity. You are one person. If the business contracts, borrows money, for example, takes a debt, or is on the hook for a contract to perform, that individual is on the hook. But with limited liability, it's separate. It's separate from the owners. And of course, the third key point here is that the business can be, a company can be used for pulling and protecting intellectual property. And the key thing, the key point to note there is some businesses are bigger on intellectual property than others. Some businesses maybe some businesses may be service-based. In a service-based or in a product-based business, perhaps IP is not a big issue. But in a tech business, for example, the intellectual property, or in a creative business, for example, the IP is critical. You understand? And so as a way of preserving the IP, particularly where you have other persons, joining to develop products, and the best way for that IP to be held, preserved for enduring value is to do that through a company. So that the company itself is the owner of the intellectual property and can exploit that intellectual property for the benefit of its own owners. And so, and that's why, and we'll get into it further down the line, that's why for large tech companies, for example, large creative businesses, most of those who do the creative work or generate the ideas will enter into an agreement where they assign the intellectual property to the company, such that the company can exploit that IP, for its own benefit. So moving to the next slide. So the next critical point that I wanted us to touch on, in relation to once you've decided that you want to, for example, set up a company or a partnership, you will have to start to interface. To set a company up, you need to interface with third parties. So in Nigeria, we have a body called the Corporate Affairs Commission. In other countries, you would have, probably it might be called a company's house or a company's group, whatever it's called. That's usually where you go to set up your business. Now in Nigeria, using Nigeria as a test case, in Nigeria, the company's house is the Corporate Affairs Commission is the house where depending on whatever kind of company or entity you want to register for your business. If it's a business name, you have to interface with the company, with the CAC. If it's a private company, a public company, you have to interface with the CAC. If it's a company limited by guarantee, or a non-profit or an unlimited company, you have to interface with the CAC. It's only in relation to certain kinds of partnerships that you do not engage with the company, with the CAC in Nigeria. And I'm guessing that in other countries as well, in Africa, there is a company's entity that registers, sets up, that you have to file with, and in Nigeria that's called the CAC, and the law is called the Companies and Allied Matters Act. Of course, once you form a company or a business that is external to you as an individual, of course, then the company then becomes liable for its own tax. Remember, if you were running your own private business as a sole proprietor, your tax is the business's tax. But once you form a company, you then begin to think about the tax liability of the company. You have to think about companies' income tax and other taxes that other laws impose on companies doing business in your country. And underlying all of that is something called a tax identification number. Once you have a company, the company has its own TIN, that's tax number, separate from you as an individual. But of course, in a business name or a sole proprietorship, your tax is the business's tax. You pay tax on the income derived from the business. And then the state tax authority, so the local taxes that you have to pay. So beyond taxes you pay at the larger sort of federal level, there may be local taxes or municipal taxes and collections that your business is liable to pay based on where your business is situated, or is set up. And of course, depending on the kind of business you're doing, as I've said previously, your business may be regulated or may be carrying out regulated activity, in which case you need to engage with the relevant regulator. Or if your business is of a special type, for example, if you're dealing with consumables, when I say consumables, I mean food and drinks. Of course, you need to register with the relevant authority that's concerned with food and drinks. If you're into manufacturing, where you make things, of course, you need to register with the standard organization of your country, the standard that equivalent. And if, for example, you're into technology, to the extent that you may be partnering with foreign technical partners outside of your country, you will have to register with the Technology Transfer Office in your country. So these are just some of the should I say, third-party regulators you need to engage with. And this is critical as a summary. It's a critical point because if you don't interface with the right regulator at the right time, it could create problems for you down the line. And we'll get to that later on. So it's important that you have, so when you set up the business, you set it up properly, and if your business requires a permit or a license from a government agency, you need to get that before you can carry out that business. I've had to help many clients, and I was still on a conference call very late last night with a client that was carrying out license activity, without a license. The business has scaled very large now, and now they're being investigated by the industry regulator for that sector. And it's not a pleasant experience. They're facing, regulatory fines. They may be banned from carrying on business in Nigeria and all of that. So if your business is regulated or it's in a regulated sector, you need to check and be sure if you require any permits, licenses, or approvals before you can carry out business in that space. That's a very critical point because your business, if you're not careful, just before the business takes off, it could be shut down. And that's a critical success factor. Now you have your business. Your business has been set up. What are the key one or two contracts you need to enter into before as the business takes off, so you can be sure the business has a smooth sail as it goes on. So the first document that I want to talk about is the founders agreement. And founders agreements are usually they're not very commonplace, particularly with small businesses because of the way we know small businesses start up. It's just, as I said, it's a hobby, it's a personal interest, what have you. But A founders agreement is a document that governs the relationship between the founders of the business and the business. Because founders can come and founders can go. Founders can come and go, particularly when you have more than one person that starts a business. I've seen some should I say, recommendations or posts about businesses starting out and how, business owners or founders should try not to start out businesses alone, just to increase the chances of success. But that may be good, but once you have more than one person starting a business, once you have 2 or 3 people, personal circumstances may change. And when personal circumstances change, you need to cater for that eventuality. And that's what a founders agreement tries to achieve. So let's assume myself, Shei, and the third friend, started a business together. We are all co-founders, it's a very nice title, co-founders of a business. Everything is going well. But perhaps my second personal circumstances change. And perhaps maybe my personal circumstances such that I need to emigrate to another country, or I can't focus on the business with the uncertainties of the business, and I need to get a steady job, and so I need to leave the business. The founders agreement deals with what happens in those scenarios, those eventualities. It deals with how the business can benefit, from that initial work that the founders have done in an enduring way. So, for example, if for example, as I've said, three people start a business, but one person has to emigrate to a different country, and the business is not of a nature that allows that person to contribute remotely. If we don't put the right structure in place, Shei and I can continue to do all the legwork, do all the sweat work that needs to be done to build that company. And then that third party who may have left perhaps maybe 2 or 3 months after we started the business will continue to derive value and extract value from the benefit from the business. And that's not fair, that's not balanced. That could lead to conflict between the founders. It could lead to a premature death of the business, to be honest, because the founders then spend energy and time dealing with that issue rather than focusing on growing the business. And so founders agreements usually will deal with those sort of scenarios. We'll set out the names of the founders, the business, the contributions of the founders to the business. And it deals with what happens if there's a premature exit of one of the founders of the business. It deals with how the business is owned. It deals with vesting and cliffs. Vesting and cliffs generally talk about how your stake in the business would vest over time as you continue to work. And vesting can be tied to certain milestones. It could be tied to timing milestones where the shares or the ownership in the business vests in the owners and founders over a period, or it could vest, based on key milestones, so key deliverables, key performance indicators. It could also deal with termination of the founder, as I mentioned. It could deal with management rights. It could deal with assignment. These things are critical, for a business, particularly when you're starting out your business with at least 2 people. It's always important to have that. And what happens if both parties decide not to do the business anymore together? If Shei and I come together, we've had a great run, maybe 2 years, 3 years, we've grown the business to a point, and then we then decide for whatever reason we want to dissolve the business. What happens? And how we deal with that, how we unpack the business, some of the things that the founders agreement will cover. The next thing is in relation to employment contracts. And of course, once any third party is joining the business, it's absolutely critical to have an employment contract. And that includes a CEO, where the CEO is or is not the owner of the business. It's always critical to have an employment contract because it's very clear. It makes it very clear what the employee is entitled to, what the employee is required to bring and not bring, and what the employee is entitled to in the course of the work that he or she does in the business. And I know that many times, because sometimes when we start a business, our business can grow faster than we expect, and there's no time. You're now trying to make sure you fulfill orders, you meet client requests, client demands, and you don't quite have time. You just find someone who has the skill, just come aboard, we'll deal with the other formalities later. That could be a recipe for disaster, And what could help is to, as you're starting out your business, chart out where you think you may require support. And in the earlier, more temperate days, have an draft employment contract on the table, have a draft JD, job description on the table. Let it be very clear what this employee is required to do. We have had to deal with many instances with troublesome employees at senior levels, at junior levels, and it distracts the founders of the business from pushing the business. So employee contracts are critical. Obviously, if you're in a business space where the knowledge of the business, knowledge required for the business is sensitive, there are things around non-compete, being able to work for a competitor are critical. Using a very simple example, telecoms companies, multinational telecom operators, they're very, very big on non-compete. So I don't want to mention any names, but if you work with one entity, usually as a senior employee, a senior member of the firm, of the business, usually you would have a non-compete that says you can't work for a competitor, for a minimum period of time, and things like that. And that's just because that's to preserve, trade secrets, to preserve confidential information, and to not to give an undue advantage to the next person. So some businesses, depending on the nature of your business, may be very critical and preserve that kind of information. Other documents are IP assignment agreements. I've touched on this previously, where basically this agreement transfers ownership and rights of the IP from one person to another or to the company. Under this framework, an individual will transfer or assign the rights in the IP to the company. And that essentially is to preserve the intellectual property. Imagine if I joined, let's assume what Powen is a company, and I joined Powen, and I did all this great work for Powen, right? And then I left the business, and I didn't enter into an IP assignment, right? I could perhaps take all of that with me, and Powen is back to square one if, there's no proper structure to capture knowledge, manage knowledge, and all of that. But the idea is, as employees come and go and continue to build the product, build the business, it's critical that that IP stays with the business, but the business can continue to exploit it and take the benefit of that. And that's very critical, because you could get into, if not carefully managed, there are disputes. And at my firm, for example, we have an entire department that deals with intellectual property, enforcement, protection, registration, conflict, and that's because intellectual property for large companies around the world, for businesses like Coca-Cola, for example, large businesses, the IP is what makes the business, is why the business is so valuable, and you never know where your business could get to. That's why you need to preserve your IP from very early on. And a very simple document, just as an indicator, basic, is an NDA, which is about preserving confidentiality of information. So and this is critical because as you're growing your business, you want to enter into partnerships with third parties, you want to sign up counterparties, strategic partners, you want to do a partnership, explore. Some of those partnerships will work out, some will not. And so it's critical that you preserve, the confidentiality of the information you'll be sharing with that partner in the early days when you're exploring the partnership. So NDAs are very simple, very standard document, but are very critical, can be very critical to preserving the value of your business, particularly in its very early days. So moving to part B, and I think I need to pick up the pace. I've used almost 30 minutes on part A. So what is corporate governance? Now, and I know that the way we start businesses in this part of the world, is very informal, but sometimes you may find that your business, has evolved to the point where you need to start putting structure around it, particularly because you want to be attractive to investors, you want to be attractive to potential customers, you want to be attractive to potential clients, and even future employees. You want to show that your business is structured. It's not just, something you're doing on the side, and that's where you need to start think about corporate governance and best practice. Corporate governance, in summary, is just a set of process, customs, policies, that guide the way the company is directed, administered, and controlled. How do we run this business? So let's assume Sheyi and I are married now, and we started a company. Are we running our company from the bedroom at night when we're having chit chat over dinner, or are we running this company properly? Are we directors in the company? Are we convening the right kinds of meetings? Are we having does the business have the right organs, the right structure, the right process, the right policies? That's what corporate governance is all about. That totality of structure that underpins the business, that ensures that as the business is taking off, it's a sustainable. There are processes that can run, in the absence of the founder. That's what corporate governance is. The right reporting lines, the right organizational structure. That's what corporate governance is really about. And it deals, as I said, it deals with the process through which corporate entities are governed. In Nigeria, members, and I think this is not just limited to Nigeria, but generally companies will have a board of directors, that have certain duties under the law, duties to act in the best interest of the company. They're fiduciaries. They're responsible for the day-to-day management of the business. They're responsible for guiding the business, the administration of the business, particularly for those in executive management. That's part of what corporate governance looks at. Now, just some elementary corporate governance practices, just to illustrate, and number one, I've said, have a board. If you have a company, at the point at which you're incorporating or setting up your company, you will be required to have a certain number of directors. It may be one in your country, it may be two in your country. But you need to have, so when you form a company, usually you have two directors just so that you can form the company and establish the business. But beyond that, and as your business continues to evolve and grow, you may need to have a board in place. And that's to properly constitute a board. Not have directors for the purpose of incorporation or establishment, but to have a board of directors properly constituted, properly set up, to direct and manage the business. And your board can, depending on the size of the business, your board can be as little as 2-3 people, can be as large as, I've seen boards of 15, 20 people, depending on the size of the operation. But the critical thing is that if you have a board, your board should, the directors on the board should be aware of their responsibilities to the business, to direct the business, provide insight, support, and they should be aware of their responsibilities, not to be conflicted, to act in the best interest of the company, not to make secret profits, and to exercise the right care and skill of a director. 2, board composition should be made up of individuals with the right technical expertise, stature, and reach. And this is critical. I know in this part of the world, because we're very communal, in Africa, it's not uncommon to have a company, and on the board you have the founder, which is the main proponent of the company, perhaps a spouse, children, family members, brothers and sisters, just because it sounds like the right thing to do, or it's the right thing to do culturally. We've seen lots of that, and when companies are looking to grow, the directors on the board of the company should be able to add value to the company, and that value can be based on their technical experience or expertise. So if, for example, you're going to form your business was around financial services, a small business around financial services, maybe perhaps micro loans to women entrepreneurs and the like. You want on your board someone who has experience in financial services delivery, many years of experience, to can provide that kind of guidance to the business. You want someone with stature, someone that shows that the business is credible, that brings credibility to the business. And you also want someone with reach, someone that can help, get the business, get you through doors you can't walk through on your own. And that's why you see, for large businesses, for very large businesses, you will find that the board composition is very diverse. Particularly in Nigeria, for example, large businesses you will find have a senior lawyer on the board to give that kind of legal direction. You'll find large businesses sometimes have a traditional ruler on board, to be able to appeal to local community. You will find that a large businesses sometimes have, a senior accountant, a senior finance person, a senior HR specialist, that can bring that unique perspective to the operations of the business. So it's critical that when you're composing your board, you don't necessarily just populate it with family members and nice to haves or friends, just because you want to carry them along. The people on your board should be people of value. And I kind of emphasize that gender parity, my term 3 gender parity. I mean, that goes without saying. I'm speaking to a largely women network here. It's critical that you show gender parity, on the composition of your board. Some businesses are composed strictly with men, some strictly with women. But we all know that there's a unique perspective each gender brings to the table. And just even from a more contemporary perspective, we're doing business in the 21st century. Clearly, gender issues are a front burner issues, and you need to represent the board. The board is properly representative of both genders in a way that show that the business is an inclusive one, and this is just a best practice thing globally. Point 4, it's not enough to just constitute a board. You need to have the board meeting. You need to call your directors together so that you can take benefit of their knowledge. You can extract the value that you've appointed them to bring. You need to have those board meetings. Small companies can have board meetings twice a year. Some have once a quarter. Some have meetings as often as they may be required. But you need to have those meetings. And for a business that is just starting up, that just has a board, it's good to have those meetings so that you can institutionalize the right kind of behavior. You can ingrain it and make it form a part of the culture that we have, that we composing a board meeting where critical decisions that affect the business are taken, are deliberated upon, and are taken and are decided upon. Have board meetings as and when you need to. And then number 5, have shareholder meetings. Hold those meetings. Shareholder meetings are different from board meetings. Board meetings are meetings of the directors of the company. Now, you may have directors that are not shareholders in the business. So if, for example, Sheyi forms a company today, and perhaps herself and her business, you could approach me and say, Dami, you're a great lawyer, we like your perspective, we want you to join the board of this company. And I could join the board of the company, but I'm not the shareholder in the business, right? So I'm just bringing that independent perspective to the company, which is great. I will be invited to join to the board meetings, and I will join the board meetings and share my perspective. But I will not be a part of the shareholders meetings because I'm not the shareholder of the business. So the shareholders of the company also need to meet. And the reason why there's this distinction between board meetings or the board and the shareholders is because the law recognizes the two entities, the shareholders, as an organ of the company that can take decisions, and then the board of the company is also another organ of the company that can take decisions for the company. And they sort of serve like a check and a balance, you understand, simply because some directors may not be shareholders and some shareholders may not be directors. So there's sort of a check and a balance against one another. But critically, those two organs need to meet. Again, as I said, to institutionalize the right kind of behavior, to bring that institutional discipline, and then to also facilitate, decision making. So, what are some of the best corporate governance practices? We touched on these already. Said have annual general meetings and file annual returns. Under the law, companies are required to have general meetings of shareholders at least once a year. At least once a year, you must have an annual general meeting. I'm sure you might have heard or seen somewhere in the news about large corporates having their AGMs at the end of the financial year, during which they prepare the financial statement, have the general meeting, approve the financial statement, and then they file what is called annual returns, So a company is required to hold an AGM within the first 18 months of its incorporation. Excuse me. And so that means once you form a company, you must have an AGM within 18 months. That's often called a statutory meeting. And most of businesses at that point, you should also appoint auditors that can prepare the financials and look at the financials. And these are critical steps because as you're looking to build your business to the point where you're attractive to shareholders, third parties, these are some of the things that shareholders and third parties are going to want to see to be sure that you are thinking about your business seriously. So they should think about it seriously. And also because from a regulatory perspective, you may be required to have audited documents, audited financials that are done. Every employee should have an employment contract. We've touched on this previously. It's fundamental, from an HR perspective. Everyone should have an employment contract that is clear about the job description, that is clear about what their job descriptions, their KPIs, their remuneration, their entitlements, and all of that. Have a company secretary. The company secretary is the one who polices the company from the corporate perspective. It's kind of like the way a doctor takes care of a human being, is the way a company secretary is to a company. The company secretary is the one that makes sure, as a corporate entity, as a legal person, the company does everything it's required to do when it's required to do that. Convenes the board meeting, convenes the shareholders meetings, prepares the resolutions, keeps the company's records, keep the company sealed if it has one, and all of that. So have a company secretary. The company secretary may be a third party, and in most countries, lawyers, accountants, and charter secretaries can be secretaries of companies. And your company secretary can be an employee of the company, sitting within the company, or can be an external, whichever you're most comfortable with. Have an anti-money laundering and anti-bribery policy. And I know it sounds complex, but it doesn't have to be. It can just be a statement of position of the business on those issues. Don't tolerate money laundering. We don't do bribery. We don't accept bribes. We don't give bribes. Just have a simple policy. It's good for institutional building. Some businesses, as I said, are regulated, and the law requires them to have this and other policies like disaster recovery policy, business interruption policies, all of that nice to have. But the fundamental baseline one will be an AML and ABC policy. And the next thing, update your statutory books, which is the job of the company secretary. Make sure you keep those records. And the statutory books, for example, are registers of your meetings, of directors' meetings, or minutes of your shareholders' meetings. So you can have those records. Because once an investor is coming to the business, looking at the business, the investor wants to be sure that you've had those meetings when you should have had them. We want to see the integrity of the decisions you've been making. We want to see the soundness of the decisions you've been making. We want to see the track record. And these are some of the things that your corporate record and strategy books will show. Of course, you should pay your taxes when they're due. They're cheaper at that point. Of course, you should take advantage of any tax incentives. Smaller businesses in Nigeria, and I think most countries have, because SMEs are the engine room of growth of most economies, small businesses usually are entitled to certain tax benefits and waivers. So try and take advantage of those where they exist. Also try and take advantage of, as I said, subsidies, stimulus packages, and government incentives where you can find them. They're very valuable to helping your business get off the ground. Of course, obtain the applicable kind of insurance, particularly if you have a business that involves, goods in transit, or has large group number of employees. Have right kinds of insurance to protect your goods, protect the business from any eventuality. Insurance always comes through on a rainy day. So we're coming to how we now deal with some of the legal risks. So those are what we just talked about in parts A and B are right kind of structure, right kind of corporate governance internally, managing the business internally from a structural point of view. But now we're going to be talking about managing legal risk. Now, when you're doing the, I mentioned at the start of the presentation that, conflict and dispute are part of business. You can't have a conflict or dispute-free journey. But how do you manage them? How do you mitigate them? Now, one of the key sources of legal risk is contracts. As a business, you'll be signing contracts, whether you're a person, whether it's a sole proprietorship or a company or a partnership. You will be signing contracts. And you'll be signing contracts with your suppliers, signing contracts with partners, you'll be signing contracts with vendors, the third parties, you'll be signing contracts with employees. Your contract fundamentally should be very clear, should not be opaque, should not be vague, should be very clear. The contract should set up the basis of the commercial relationship between the parties and the extent of the rights and obligations of the parties. And it's critical because if your contract is not clear about what I am required to do, so let's give an example. If Sheyi invited me to speak to you today and I had to sign a contract with her to come and speak, to deliver a presentation on legal toolkit for SMEs, and we did not have a contract, I could easily come and discuss parts A and B of this presentation and say, I'm done, pay my fee, right? Not that I'm earning a fee for this, but I could say, I'm done with part A and B, pay my fee. But I did not cover part C and D, and Nishayi would say, no, but Dami, yes, you talked about business development, business establishment, you talked about corporate governance, but you didn't tell us anything about legal risk. You didn't tell us anything about regulatory issues. You didn't tell us anything about this or about that. And I'm like, well, it's not in the contract. We didn't write it. She won't be able to hold me to it. And then we could get into a dispute. I could sue her for my fees. She could sue me for non-performance of the contract. And that's just a very elementary illustration of what could happen when contracts are not clear. Think about if you were ordering 1,000 metric tons of a particular raw material for your business. If you were not clear about the specifications of that raw material, you could have parted with payment, and you could get shipped to you 100,000 metric tons of a raw material of a different grade, and that could literally paralyze the business. So contracts must be clear about the rights, about the obligations. If you're dealing with supply of goods, it must be clear about the specifications. It must be clear about delivery. It must be clear. It must be clear about your rights. It must be clear about the obligations. It must be clear about when we deem performance to have occurred. It must be very clear. And I know contracts are can be the contracts that are 2 pages, 3 pages, the contracts that are 1,000 pages, right? The important thing is that your contract must be clear about what the business is getting, what the expectations of the business are, and what the obligations of your counterparty will be. So I said key clauses here include obligations of the parties, the duration, what grounds can you terminate, and what are the outcomes or reliefs for termination. Can your counterparty just terminate the contract after you pay? Can you terminate the contract after you've ordered and your counterparty has shipped them? What are the representations or warranties that give you comfort for contracting with your counterparty? Confidentiality provisions. How do you exclude liability, limit liability, force majeure? If, for example, we all know we're all living in a post-pandemic world. Most contracts have pandemics or epidemics, as a force majeure. Force majeure is a provision that excuses performance of a contract. So if I have a contract to perform with Shay, for example, to speak to you today, but I couldn't make it because of maybe there's a strike or a lockout that prevented me from driving to where I'm giving this presentation today. Assuming there were no virtual facilities, I would be unable to perform my end of the contract. But that is due to circumstances beyond my control. That's what force majeure is. So you may want to look at your force majeure provisions carefully to see where and when you can excuse your counterparty for performing the contract without liability. And you want to limit those circumstances to as small or as close the group a list as possible, such that your counterparty does not have an excuse to not perform the contract without legal liability. So that's the contract. And of course, when you get into disputes, most of the time when parties go to court or in arbitration or in dispute settlement, it's usually because they sign a contract that one party has breached or cannot perform. Now, depending on the nature of your business, I want to talk about terms and conditions. Depending on the nature of your business may be such that you have lots of users. It could be a tech business, for example. What are the terms of use? What are the terms and conditions? I know a number of us, we all use tech platforms where we see T's and C's. Sometimes you log into a website for the first time, you see T's and C's, you just click yes, no one ever reads those things. Those T's and C's can contain very, very vital information that impact on how you enjoy the service or not. Sometimes when you open a bank account, for example, you will always see certain terms and conditions listed on the back of it. Those terms and conditions are the terms and conditions of your contract. Most times, no one ever reads those things. We just click yes, we click no, and that's what enables, for example, some data companies to share our data. We see cookie policies, we see all those sort of things. Those are things that T's and C's are critical. Depending on the kind of business you're running, you may want to have T's and C's in place that your customers can accept, and that determines what you can and cannot do with their information, their user behavior, their customer patterns, creates opportunities for you to use some of that information for the purpose of the business. T's and C's are very critical because you don't want to end up in a situation where you face 1,001 suits from potential customers. So we've said, just come back to the last slide. We've said have contracts, always have a contract with your counterparty. Try and make sure the contract is clear. It doesn't need to be extensive or long, but it must be clear. 2, with your counterparties, with your consumers, try and have T's and C's if that's the nature of your business. Can a customer return an item purchased after it's been opened? Sometimes we know personal effects. When we go to the supermarket, we know that personal effects, personal clothing cannot be returned once opened, once purchased. And that's just for the business's sustainability. These are some of the things that are critical. Of course, talk about contract with employees. Your employee must always have contracts because they could lead to disputes. Let it be clear who bears tax liability, what compensation it is, the employee is entitled to, who can terminate and when, and what the implications for termination are. Does that employee have conflict, a non-compete, or does he have a compete provision? These are critical things. As mentioned, it should have, if you're going to have a non-compete, it should have, if the employee has non-disclosure obligations, it should be clear. Some businesses, like to have their employees vested. And so you could have incentives and bonuses built into it. Be very clear. Is the employee entitled to a bonus every year, irrespective of performance? Or is it a bonus? Is it a performance-based bonus? Is it a contractual bonus? Is it a discretionary bonus? These are very critical things you need to think about. Sometimes an employee may be entitled to a discretionary bonus, but he or she, having received that bonus consistently every year for 5 or 6, 7 years, perhaps the business has a tough time in 1 year and doesn't pay a bonus. An employee sues. You need to be very clear, is that bonus discretionary? Even though it's been paid customarily, because it's not been paid in a certain year, doesn't mean it's contractually, the employee is contractually entitled to it, except it's written in his or her contract. You need to be very clear, what kind of incentives does the employee get? Are they incentives, and then are those incentives for the role the employee is filling, or are those incentives for the employee, irrespective of the role? These are some of the things that cause disputes between business owners and their employees when they come and when they go. We need to be very clear about some of these things. Of course, some businesses want to give their employees a share of the business, make them vested, make them committed, try to minimize employee attrition. And so sometimes we've seen employee stock options. Do you want to have an employee option plan where employees, after a period of time, are entitled to shares in the business so that they create shared commitment to the business? You need to think about that. These are some of the things that could create, these are some of the things where we've seen most of the disputes relating to employees and their businesses, and they could create legal risk. The employees, the founders of the businesses could be tied up in court cases, disputes that distract from business growth. Now, when you're doing business in our part of the world, there's often regulatory uncertainty, dealing with regulators. You start a business. I mean, I was on social media, I think a few months ago, I saw one business owner based in Abuja complaining about how, officers of different regulators just walk into the office, into the shop or into the store and, levy all sorts of fines, shut down the business, having that regulatory because they didn't pay an obscure, insignificant fine or levy and what have you. It can be a bit of a challenge for a business owner. So one thing I usually recommend for business owners is get a lawyer or an advisor, to do a compliance audit for you. You want to start out this business, what are the things that I need to do from a regulatory perspective? Even if my business is not regulated, what are the fees I need to pay? When do I need to pay them by? What do I need to have in place? Do I need to have a policy in place? Do I need to have this in place? Do I need to have that in place? For example, if you are a business that deals with personal data, Data protection is a big issue across the world now. If you're a business that processes the data, personal data of data subjects, you need to have a data protection compliance officer internally. Do you have that? You need to have a data protection policy in place. Do you have that? So what I advise sometimes is, if your business is at that point, get a lawyer, get someone to do an audit for you, to tell you, as a corporate entity, these are the 4, 5, 6, 7, 8, 9 things you need to do to be on the right side of the law at every point in time. So that when an inspection comes, either impromptu or planned, you have those documents you can show, and you're fine. And that doesn't disrupt your business. As I said before, if it's a regulated business and you need a license or a permit, go for those. Apply for those, get the permits. You may be lucky that your business may be one that has an approval in principle before a final approval. With your approval in principle, you can carry on business. Go for approval, always be on the right side of the law. Look out for regulatory updates and changes to the law. As I said, hire a lawyer. You can always hire a lawyer to advise you on those things. Sometimes, for example, your regulator, if you're a regulated business, can publish an update and says your regulatory obligations. Say, for example, instead of filing once a year, you now have to make filings twice or thrice a year. That's a regulatory update you need to be aware of so that you don't run foul of the law. So you need to keep an eye on those things. Changes to the law, changes to regulation as they impact your business are critical. Comply with extant laws. That's comply with all the laws of today. Even though some laws sometimes can be a bit of a stretch, it's always advisable to comply with as many laws as possible as your business evolves, because that's critical from a regulatory perspective. And I said, always stay informed about industry practices and be on the lookout for regulations. And that's sort of tied to regulatory updates, so I won't waste too much time on that. So coming down to part D, which is the last part of this presentation, and that's dispute resolution. So let's talk about preventive measures. How do you prevent a dispute? You said you can't avoid them, but what can you do to prevent them, at least so that they're not a dime a dozen, they're probably 1 in 10. Get the right advice on issues from day one. Either in relation to your business operations or in relation to contracts. Get the right kind of advice. 2, choose your counterparty carefully. And on this, I want to share a personal experience. Contracts are only as good as the counterparty you're signing them with. If I enter into a contract with Shay, if I am not an honorable person and Shay is an honorable person, I may not live up to my contracts even though I sign it. And it's clear, it's the best contract in the world, and may choose not to perform it. So it's important that you choose your counterparty carefully. And the personal experience I wanted to share was, I was advising a client, two young founders started a business, about 6, 7 years ago now. And they grew the business to the point where they were taking investors. And of course, at that point, they were very desperate. They needed funding to grow the business, to keep the business afloat. And they approached a certain HNI in Nigeria today. And they approached him for funding, and he provided the funding. And to be fair, we prepared all the right kind of documents at that time. Prepared all the right kind of documents and shared the documents with this gentleman. Gentleman did not sign the contracts. They signed, but he didn't sign. But he kept the contracts and he advanced the funding to them. He funded them, I think in USD at the time, about $100,000 or so funded. And the business, everything was going well. But unfortunately, the economy in Nigeria took a bad turn a few years later, and that began to affect the exchange rate in the country. And the business also was then affected. And this gentleman who had invested equity in the business and had become a shareholder in the business said, well, this business wasn't looking bright anymore. The prospect for the business wasn't looking good. And he called the founders into a meeting and said he wants his money back. And he wanted his money back in USD, right? And this was a business that was trading in Naira. And at that time, the exchange rate had dipped by about maybe 30, 40%, and that's when at that point the founders came to us at the firm and said, we needed support and advice. And I said, and I asked, did this guy sign the contract? They said they weren't sure, but they signed. So I asked, and and the gentleman had his lawyers write us, and we got into all the lawyering, and it turns out that the contracts were not signed. And because the contracts were not signed, the gentleman was treating himself as having lent the money to the investor, to the founders, as opposed to having invested in the business. And because he didn't sign those contracts, we couldn't sort of hold him to the contract. Yes, we knew what the intention of the parties was at that time, but there was no contract underpinning it. After further investigation, of course, it turned out that this gentleman was in the habit of investing in businesses and not signing contracts. And he had done it not once, not twice, not 3 times. And that's why it's important to choose your counterparty carefully. The way your counterparty chooses you is the way you choose your counterparty. The way he chooses to do business with you, either as an investor or as a trader, as a supplier, or what have you. It's important you choose, and that's where due diligence comes in. You need to do your due diligence on whoever you're going to go into business with, because that could be fundamental to the success of your business. So 3, without dwelling too much on that, 3, have well-drafted contracts. Ensure your contracts are clear and they have the right kind of protection for you. So protections are things like indemnities, liquidated damages, warranties, guarantees. They're contractual. Those are contractual structures that are put in place such that if you enter into a contract with a person, so for example, let's assume I enter into a contract with Sheyi to deliver this presentation, and I don't do a good job. Sheyi can say, well, guy, Dami, you have to indemnify me for the loss I may suffer. Or Dami, you may need to make me whole. Or Dami, you may need to come and do another presentation, if I'm not happy with it, if we didn't get the right kind of response or input. Those sort of things are, contractual structures that are put in place to provide protection for you in case things don't go the way you plan to, but so that the company is not exposed, the business is not exposed, those sort of things are things that protection that preserve the business. If you're doing contracts with other parties across the countries, across the world, you should have a good governing law that you're familiar with, governing your contract. And then obviously have a pre-dispute settlement mechanism. Now, just to touch on 5, dwell on 5 a bit. Sometimes you have a small contract, not very large, but a critical contract, but not large in terms of value, or large but critical in terms of the significance of the business or the success of the business. But things may go wrong. Because it's small, you may not want to spend time in litigation in court, debating, getting a lawyer to resolve a dispute. You may also not want to go to arbitration because it could be expensive. So one thing that we advise is, particularly if your business is small and still growing, have a pre-dispute settlement mechanism. So when there's a dispute between a party, you can say parties will meet over 30 days to try and resolve the dispute. If they can't resolve it, then perhaps you can then escalate to senior management, say executives of the business, to try to resolve the dispute. That way, you're keeping it in-house, you're managing the cost associated with dispute resolution, and you're trying to resolve. And if that doesn't work, you can then perhaps consider negotiation or mediation, where you have a third party sit with the 2 parties, to resolve the dispute between the parties, the contracting counterparties. In Nigeria, we have the mediation centers, the multi-door courthouse, where for a small fee, very small fee, you can have a mediator sit with you and your counterparty to resolve the dispute in a way that preserves the relationship going forward. And so often we find that for small businesses, these are very helpful pre-dispute settlement mechanisms that help resolve a lot of disputes before parties get locked up in court and for years trying to resolve disputes that are very simple and very small. So that's also something that I wanted to talk about. And if you can't prevent a dispute, if you find yourself in a dispute, of course, you need to hire an external counsel to represent you. Also, make sure that you have someone who's vested in the business in terms of committed to making sure he or she is not just using your business to tick a box. Have the right kind of counsel. As I said, explore alternative dispute settlement mechanisms so long as it meets your business's objectives. I've spoken about arbitration and mediation. And of course, if all else fails, you may have to end up in court, and that's litigation, but we hope you never get there. So if you're in a dispute, get the right kind of representation, take care, respond quickly. I know sometimes a coping mechanism can be to ignore a dispute, particularly because legal structures or legal frameworks or legal systems, I beg your pardon, have structures where if a party goes to court, if a party sues you in court and you don't appear or respond, judgment in default could be entered against you. So even if you get a court summons or something from the party, you always have a lawyer look at that for you. Never ignore, because if you don't respond on time, there could be judgment against you and you may be found hanging out high and dry. I believe this will be the last, final thoughts. So, final thoughts, I just want to talk about investment transactions very quickly. So, if your business has grown to the point where you now want to take investment from a third party, maybe Powen has a small investor loan grant that they give to young businesses. Perhaps you want to take an investment from a private equity firm, what have you. Of course, in preparation for that, some of the things that we've talked about, particularly in part A and B, critical, and even some of part C, have the right kind of documentation, have the right government business and corporate governance practice, have the right kind of structure to your business, update all your necessary filings. These are things that will make the due diligence an investor will do on you simple, seamless, and it signals to your potential investors that you're thinking about this business seriously, you're taking the business seriously, and they should take your business seriously. It also goes to your valuation. It goes to ensure that, it goes to see that if things are done properly, taxes are paid when they should have been paid. They're not unmet liabilities, statutory or what have you. You're doing everything you need to do properly. Employees, there are no cases or litigation that have a monetary value there. Those things help to enhance the value of your business and make sure you get true value for your money, for the investment your investor is bringing. Two, I've said make all necessary post-transaction filings and documentation. So once you're done, and I don't want to spend too much time debating the process for the investment, but make sure all filings are properly done and documentation properly done. Like the example I gave, the documentation from the investor or that investor to those two founders, the documentation wasn't properly concluded. Make sure all documents that need to be signed are signed, records are kept as they should be. And of course, hire a lawyer for investment transactions to protect your interest and to structure your deal appropriately. Pay attention to key clauses in the document. Some documents you will see are term sheets, shareholders agreements, share subscription agreements, and loan agreements. The last point I want to make on this point, just to say, is you need to be and that's why it's important to hire a lawyer, because sometimes, and I know we've all seen movies where business owners who set up companies, large companies, and they get pushed out of their companies. Sometimes you could find that you own a business, you spend 20 years building your business to a point, you brought third parties into the mix, and then you could find yourself pushed out, because of an investment you took 10 years ago, 15 years ago, and there was a clause that gave that investor the right to outvote you, for example. You want to make sure that you're not an employee in your own company where you have accommodated other parties to bring value. So that's why it's always critical. At the point at which you're taking investment, make sure you have a good lawyer that is supporting you on that helps you keep an eye on those booby traps that could be in there, to make sure that you're fully protected and you don't get into dispute. I think that brings me to the end of the presentation. I know I've been speaking a lot, but I'm hoping everyone has heard me clearly, and I'm hoping there are questions that I can answer. And I'm hoping it was a helpful session. Thank you all for listening.
Wow, Dami. I mean, ladies, you would agree with me that for everyone on this call, it's a privilege for us to have one of Africa's finest lawyers take us through the session. I think this has been the most, I've attended a lot of legal sessions, but I think this has been the most detailed. And I advise everyone, go through this session again and make sure you create a checklist for your business. Yes, I know a lot of people have been saying, oh, there's so much to do. Yes, I hear those comments. But guess what? For every point that he has mentioned, I can think of at least one company that has gone down because they did not do that, right? So many examples. The statistics is not an exaggeration. I did my MBA thesis on the reasons why businesses fail. And trust me, I can relate with every single point that he has made. So ladies, please let's go watch the session again and ensure that you create your own checklists. Don't base it on another person's checklist. Your business is different from someone else's business. Even Payone as an organization, I'm like, okay, we need to do a checklist, of someone, because there are some things that, we have skipped, yes, in the process of our incorporation. But let's say thank you so much, Dami. Let me go to the questions right away so that we do not waste time. I can't obviously take all the questions, but I'll take, what I've done was to try to answer the ones that I could, with my small knowledge. But so I'll start with the questions that came in before the session, and I'm just going to take 2 or 3. Okay, so Amechi Messi is asking, is having a legal arm in your business necessary? And if yes, at what stage of the business should that come in?
That's having a legal arm, right?
Yes, a legal arm, like a legal department.
Yes. So thanks for the question. If your business is not so large, if it's still a small business, you don't have to have a legal arm or legal department. If your business is at the point where you have grown, if you have, say for example, anything between 5, 6, 7 employees, it may be good to have someone who's a lawyer who can, do, as part of his or her day job, deal with some of your legal needs as a business, at least give you a first overview, first eye view on some of those legal contracts and things that you may need to do, and advise you appropriately. But it's not a requirement anywhere. There are some businesses that don't have any lawyer sit inside, who sit with the business. They just outsource them to law firms or to law chambers or to lawyers outside that they know. It's not a requirement. It's not fundamental. But as your business grows, you will find that sometimes it may be easier for responsiveness. You may find out that you also want, the truth is that I'm a lawyer I'm working at a law firm. I don't work with a business. And so even though I have experience working with certain businesses, I can't understand the business as much as you who are in the business as well. And so sometimes businesses feel that they want to hire a lawyer who understand the culture, understand the sensitivity of the business better than any third-party external lawyer could. So if your business is at that level where you feel you need someone to provide a first response on most issues, to deal with issues, you can hire a lawyer, and you can afford it. You can hire a lawyer internally. And there's some businesses that have 20 lawyers, 30 lawyers, 40 lawyers. Some have 1 lawyer. It all depends on operation and your legal needs. It all depends on that. But I will say, the last point I will say is that because of the rules of professional conduct, there are some things that lawyers who work within the business cannot do. So a lawyer that works within the business, for example, cannot appear for you in disputes, particularly in court or in arbitration. There has to be an external lawyer. But otherwise, lawyers are qualified to do everything, really. It all depends on how they sit. I hope that answers the question.
Okay, yes, it sure does. And I'm going to ask, a relevant question to that from Sitabile from Zimbabwe. She's asking, so as a startup, legal representation for businesses come at a respectable fee. I don't know what she means like this. Are there ways of working around the cost element?
So yes. So what I will say is that there are some, when you're starting your business, you don't have to go to the fanciest law firm in town, right? The way law works, lawyers are qualified personally, and then some may choose to work at a firm. So I am a lawyer, and I can advise personally, but it doesn't mean that because I work at a firm, if you walked up to my firm, you would have to, probably pay a respectable fee. But we all have friends who are lawyers who can eyeball a document for us. She has asked me as a friend to facilitate this session. I've shared my experience at this session, so you can reach a friend, neighbor who's a lawyer to eyeball some things for you, at least at the very early stages of your business. But as your business grows, you will need to have a part of your budget to do with your legal needs. It's important that you do that. But I agree, and I know that and that brings me to the other point about managing cost-effective money. There are a number of platforms that exist today where you can get legal services, at on a budget. For example, at my firm, we have something called Lani Digital. That's www.lanidigital.com. I'll pop it in the chat, where you can go as a small business and you can buy some of the documents that I've spoken about for a very small fee, say $5, $10, and you can use it. It's a self-help platform that you can use. So when your business is still very small, but you know that document has been prepared by good lawyers, so you can take it and use it. You want to enter into a supply contract, you need an NDA, you can go to lanidigital.com and buy those documents, for a small fee. And they have lots and lots of, they have over 120 documents you can go there and buy. And not just Lanidigital, there are many other platforms that have that. And I know they probably have that across in other countries as well. You can go there, buy a document for cheap, and use it to protect yourself.
Okay, thank you, Dami. Can you please just share the link, the website?
Yes.
Yeah, because I think that would be very, very super useful. Okay, yes. All right, so whilst I read the next question, so we have Gladys Shumbambiri, and the first question she's asking is, how do you deal with legal issues that surround a family-run SME? And I'm particularly vested in this question because one of the participants from last year, she called me sometime in December and, was just sharing her experience, how she's been managing the company business, but I think someone died, maybe her father or her mother died, and she was forcefully taken out of the family business, right? So yes, and but she was, she was just calling to even tell me that she was able to start her own business based on the knowledge she gained from the program and all. But for me, I was actually quite taken aback that, how can you run a family-owned business for over 5 years, and then just because of the death of someone, you're forcefully asked to relinquish management of that organization. So going to her questions to say, how do you deal with legal issues that surround family-owned businesses?
Okay, Shay. So a number of factors, and sort of ties into everything I've said during this afternoon.
Yes.
Depends on what the structure around the business was from the time it was set up. Who are the shareholders of the business? Who are the directors of the business? It may well happen that that lady you're talking about may have just been a director of the business, but not a shareholder of the business. In which case, she would have just been removed as a director and she's out. So it depends on what kind of structure is around the business. That's number one. And that's from a corporate perspective, just dealing with the business from a corporate point of view. Is every member of that family a shareholder? Is every member of that family a director? If that lady was a director and a shareholder, the fact that she may have been removed as a director doesn't mean she's been removed as a shareholder, right? A different thing needs to happen for her to exit the company as a shareholder. And it could have been the other way around. And it could also have been either. She could have just been working for the company as an employee, thinking that she was, even though she's a member of the family, she was entitled to an ownership stake in the company, but she may not have been. So the fact that you work in a business, even though it's a family-owned business, doesn't mean you have any, you may be no different from the next employee who's not connected, who's not a family member. So it all depends on what was done around her involvement in the business. Was she brought on the board? Was she brought onto the company as a shareholder? Or was she just an employee or a consultant? That's one. On the corporate. And on the other side, it could also be from an estate planning, personal succession perspective. If the business was started by her family, and when that person passed away, perhaps in the last will and testament of that person, he or she may have ask that this lady be excluded from the business, or that person gave the business to other members of the family to her exclusion, that could also impact on what may have happened to her, irrespective of her status in the business. So even if she was a director and a shareholder, the owner, even though she was a director particularly, the owner of the business could have said, at my dying wish, X and Y should happen to that person, and the executors of that person's will may take those steps to have that happen. But I will say though that as a shareholder of the business, the law says that your shares in a company are personal property. So only you are the only one who can deal with your shares. So if I have shares company that my father started, there's nothing like my father's company. If I have shares in the company that my father started, right, and I'm a shareholder, on his passing, he can deal with his shares in the company, right? Because they are his personal property and his will can say what can happen in relation to those shares. But he cannot deal with my shares in the company. So I'm suspecting that lady may not have been a shareholder in the company, in the company, sorry. And if she was not a shareholder, that she was not entitled to any profit from the business or what have you, and she may not have a role in the business if she was not a director or a member or an employee in the company. So it all depends on what may have transpired, and we can talk a bit more about that offline to share more views.
Thank you so much, Dami. I didn't even bother asking, the legal. She was over it anyways. So because of time, I'll only ask 2 questions. Ladies, there are some questions I'm not taking because they have either been answered by this session or by other sessions. So for those of you asking questions on tax, please go and just watch the tax session again. All those questions have been on tax and CAC. Just go and listen to the tax session. That has covered everything. So but someone is asking, so Evelyn from Kenya, right? She's saying, online businesses, what regulatory documentation or what regulatory, how does she get to know which regulatory framework governs online businesses?
So that's a good one, and I hear that a lot, Shay. And you know that, remember, the first thing to say is there are many businesses that are not regulated today, particularly in the informal sector in Africa. You could start perhaps making clothes, for example. There's no real regulator you're going to apply for a license, to carry out, to do that. If you're perhaps making children's shoes, for example, there's no real regulator in that sense, other than eventually getting to standards when you want to export and what have you. But if you're doing a business, and you want to deliver or fulfill aspects of your business online, if the business is not regulated, then it's not regulated. You just need to then ensure that you do things from a best practice perspective, do things properly, from a best practice point of view. But what I can tell you is that because the world is now fully digital, and a lot of online presence, and e-commerce is taking off, and buying and selling is being done online, services are being provided online, and all of that. Because of that, the government is becoming more aware that a lot of things are happening, commercial activity and economic activity is happening online. And for example, the Finance Act, which was passed recently, has some rules and provisions on businesses that are conducted sort of, should I say, digitally or online, and it imposes certain tax. It deems once you cross certain thresholds, it deems you to be having had significant economic presence in a particular place, and for that purposes, you then pay tax and all of that. So I guess depending on what that lady's business is, it will be good to speak with an advisor, maybe a solicitor, to say this is the nature of business he or she is doing, and to ask what rules or regulations apply to his or her business. It may well be that there's no rule, there are no regulation applicable to the conduct of that business activity, but there are rules that apply to that business as a company from a corporate perspective. So as a company, you need to have your AGM, you need to have your returns, you need to file your reports and all of those things. So you may not have a sector or industry regulator, right? But you may, but as a corporate, you will have some obligations from a regulatory perspective.
Okay, so I'm just going to take 2 questions and that's it. So someone is asking, what kind of lawyer can do a compliance audit?
Okay, well, depending on your business, if your business is sort of specialist, then it will be good to get a lawyer in that space, even though the truth is any competent lawyer should be able to do that review for you. I mean, there's some lawyers, for example, I do a lot of tech work, just to illustrate, I do a lot of tech work. So if you had a tech business, someone had a tech business, I could easily just off the top of my head tell you what I think you need to do and all of that. But if someone approached me who was doing manufacturing or something, you know, I can, with time, do that, give that advice. I just need to perhaps look at the rule, look at the books, and come back, you know, with that advice. So any sort of, should I say, decent lawyer, any competent lawyer who can do an audit for you. It's just about he or she checking the rules in relation to your business. And lawyers are trained for that. We have those skills, checking the rules to see for this business and then coming back to advise you. So anyone can do it.
Okay. Benzejo says that in Cameroon, they have corporate lawyers that specifically do compliance audits. Fantastic. Okay, so my final question, is taken from who asked the question? I think it was Beatrice Kalu that asked the question. And she said, in the example that she gave of the counterparty that did not sign the contract, as a startup, what should you do in this instance? If you are faced with that kind of a scenario, what should you do?
Okay, so when you're starting out and you're entering into contract, there's sometimes when you probably have a better bargaining power, and other times when you don't. So, for example, if you're looking for, if you have someone who's is a supplier, for example, supply contracts. In that sense, the counterparty sort of needs your custom, so you can actually ensure that he or she signs, or the supplier signs before you sign. Other times, it's usually good to have something, it's not called a signing ceremony, but have parties meet together and sign the contracts together. You usually have these issues where one person doesn't sign, when you have one person signs and has to send the contract to another party, and then you never know whether the person has signed or not. If possible, try to meet together. And I'm sure we've all seen these things in the news where the government is signing a major contract, they have pictures taken, you have large boardroom, people in boardroom seats signing documents, particularly when you have multiple parties to a contract. So if you can, once you have a contract in place, sit together with your counterparty and sign the contract together, and if you cannot, but be apart from the counterparty, request, before you start performance of the contract, request for a signed copy of the contract to be sent to you. So if you send the contract, if I send the contract to Shay may be in the UK or London or anywhere else right now, I could send the contract to her, and then I say, before I give this presentation, or before I start preparing my slides, you need to give me a signed copy. You understand? Before I make a payment, I need to see a signed copy. Before I ship your order, I need to see a signed copy. That's some of the ways you can mitigate that situation where your counterparty doesn't sign. So just coming back to that illustration that I gave, before that investor, if I were the counterparty, I would say, before I take this investment, sir, please sign this contract, and let's file it away for both our records. You understand? Because if you remember, that investor did not sign the contract, but he ensured that the founders signed the contract. So I think there are many practical ways you can deal with that situation. There are many practical ways to deal with that situation to deal with this not signing counterparty.
Thank you so much, Dami. Please don't forget to send us the website.
Yes, I'm I actually realized that I shared it.
Oh, okay. Thank you so much. Ladies, I think this is, we couldn't have asked for a better final masterclass. Yeah, thank you so much, Dami. This is the final masterclass, but it's not the last session. We still have our closing ceremony on the 31st of August. I will be taking that session, so let's make it a date. And on that note, I'd like to say thank you to everyone, and do enjoy the rest of your planning for the physical meets. Thank you so much, Dami. Thank you so much.
Thank you very much, Shay. Thank you very much, everybody, for having me. Happy to have been part of this. Shay, I think the slides are available. You can share with people.
Yes, yes, I'll share it out. Thank you so much. I'll call you now, Dami.
Thank you, everybody. Have a good day. Bye.
Wow. You're welcome, ladies. You're welcome. You're welcome. You're welcome. Clap, 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 clap. Woo! Okay, so someone's raising hand. Okay, so now I can take your raised hands. Let me see. Let me see. Okay, no, the person has. Okay. All right, ladies, I have to go now. So much learning. Yes, yes, yes. Amen to everyone saying God bless me. God bless you too. But please don't forget to go back to the session and do your checklist. Please do your personal checklist. There's been so much knowledge that has been, that has been given in the session. Please, please. God bless you too. God bless you too. All right, ladies, I have to go now. Thank you. Do enjoy. Parent is so amazing. Yes, I know. I know. I advise you to do so. I advise you to do so. I'll be providing a lot more information. Oh, I forgot to mention, you don't want to miss the closing ceremony though. Some people will be getting free websites. Yeah. I know when people have left. Yeah. So some people, yeah. Some people will be getting free websites. If you have done the hard work, you will get your website free of charge. Woo! You're welcome, ladies. I love you too, Fania. I love you. You're welcome.